Please begin when you're ready.
Does a mandate for insurers to cover the cost of birth control violate the Constitution? Simply put, no. While the First Amendment guarantees the free exercise of religion, this mandate does not violate those protections because it allows exemptions for certain religious institutions. Those institutions not granted exemptions are legally bound to the mandate because the right of free exercise of religion does not relieve an individual of the obligation to comply with a valid and neutral law. Since this mandate's aim is to ensure gender equality, the law is both valid and neutral. Therefore, it is constitutional. Powers given to the federal government are limited to those enumerated in the United States Constitution, Article 1, Section 8. Under the 10th Amendment, powers not granted to the federal government, nor prohibited by the Constitution, are reserved to the states or the people. The Constitution is silent on the issue of insurance. That is why in 1948, the Supreme Court was able to decide that the issue of insurance should remain in the exclusive domain of the state. Both New York and California have adopted laws ending gender discrimination in the realm of health insurance. The New York Women's Health and Wellness Act requires that insurance plans that cover prescription drugs must also include coverage for contraceptions. 26 other states have laws similar to New York and California, and of those 26 states, 21 allow coverage exemptions to certain religious institutions. If a state determines that insurers should cover birth control costs because it would end gender discrimination, they are legally entitled to do so. And if a state determines that insurers should cover birth control costs because there is an economic rationale, mainly that women spend more out of pocket to cover birth control expenses than men, they are legally entitled to do so. In 1982, the Supreme Court ruled in United States v. Lee that the right of free exercise does not, may I repeat, does not relieve an individual of the obligation to comply with a valid and neutral law, even if the law has the effect on a religious issue. The intent is all that matters. And if the intent of the law is both valid and neutral, then individuals not afforded an exemption are obligated to comply. The court echoed this sentiment in Employment Division v. Smith in 1990. Valid and neutral laws are generally applicable, and they may be enforced over the objection of religious dissenters. Now, the main contention with this mandate is that the exemption doesn't go far enough to allow those institutions that are religiously affiliated but with secular goals to be covered. In Catholic Charities v. Superior Court, the U.S. Supreme Court held that the free exercise of religion does not excuse compliance with neutral laws. To allow religiously affiliated institutions with secular goals to deny their religiously neutral employees access to birth control is discriminatory. In 2000, the Equal Employment Opportunities Commission ruled that employers cannot discriminate by denying coverage of contraception. The Supreme Court has already said that the freedom of religion does not trump a valid and neutral law that has a secular aim. This state law is promoted by economic means and the need to end gender discrimination. Because the state law has a valid, neutral, and secular purpose, and because the issue of insurance is an exclusively and expressly state issue, this law is valid under the Constitution. Thank you very much.
In the United States today, there are currently 62 million women of reproductive age who have used contraceptives at least one point in their lives. Some of these women have used it to maintain their reproductive health. Some have used it to gain more control over their lives. And over half of these women, over 31 million women, have also used it to treat medical conditions. These are important issues of individual health, and the Affordable Care Act's contraceptive mandate enables women to have control over their futures and their bodies, and enables them to treat potentially debilitating conditions. And that is the purpose of this act. That is what the contraceptive mandate is intended to address. The intent of this act has never been to control or impede on religious freedom. But nevertheless, opponents of this act claim that requiring employers' insurance companies to cover the cost of contraceptives somehow violates the free exercise clause of the First Amendment. But any effect that this act has on religion is merely incidental to a much greater purpose: to maintain and promote women's health. Now, this act is aimed at enabling women to treat painful and debilitating conditions such as endometriosis and to prevent the development of ovarian cysts. It is aimed at enabling women to control hormonal imbalances and treat conditions such as premenstrual dysphoric disorder, which can affect their social and occupational functioning. This is an act aimed at enabling women to control their decisions over very personal and private matters. In other words, this act's purpose is purely secular: to promote women's health. Now, despite this secular purpose, opponents still claim that it unconstitutionally burdens institutions whose religions forbid them from funding, using, or promoting contraceptives. But this argument fails. This mandate, like any other federal rule or law, is premised to be constitutional. And because this act is not aimed at controlling or impeding religion, that means that a person cannot fail to comply with it. And an argument that it is unconstitutional blatantly flies in the face of this country's free exercise jurisprudence. The United States Supreme Court has consistently held that a person cannot fail to comply with a facially neutral law of general applicability simply because they claim it prescribes something that their religion proscribes, as long as the law is not aimed at controlling or regulating religion. Now, this rule makes perfect sense, because if we were to hold otherwise, we would enable the will of the religious to control the secular will. We would enable religious groups to be able to prevent women from being able to have control over personal and private decisions, and would be preventing them from being able to afford to treat painful, debilitating conditions that affect not only their health, but their overall quality of life. Given the controlling precedent in this country, it is clear that the Affordable Care Act's contraceptive mandate is not unconstitutional. Thank you.
Mandatory insurance coverage of the cost of birth control is not a new idea. Just this past February, the National Conference of State Legislators reported that 28 states currently have laws that require insurers to cover the costs of birth control. 8 states have mandates that do not provide any religious exemptions whatsoever. And an additional 4 states carry mandates with very narrow exemptions that are available only to churches and church associations. Though these laws have repeatedly been upheld in state courts, and though they've been on the books for almost 20 years in some cases, many Americans have suddenly revolted against them, claiming that these laws are unconstitutional, that a mandate for insurers to cover the cost of birth control is an egregious and unprecedented attack on religious liberty, that it forces employees to purchase a product that conflicts with a deeply held religious belief. These fears are valid, and they ought to be considered when legislatures draft exemptions to these mandates, but they do not make the mandate unconstitutional. A mandate that requires insurers to cover the costs of birth control applies generally, and it does not single out any particular religion. Therefore, the mandate cannot be viewed as an unconstitutional intrusion on the rights of any particular religious group. Challenges to mandates that require insurers to cover birth control inevitably center on the free exercise clause of the First Amendment. It states that Congress shall make no law respecting an establishment of religion or prohibiting the exercise thereof. Opponents of the mandate often rely on variations of the Sherbert test, which was introduced by the Supreme Court in Sherbert v. Verner in 1963. Under this test, governmental action can burden an individual's sincere religious beliefs only if the government can prove that the law is furthering a compelling state interest in the manner that is least restrictive to religion. However, this broad interpretation of the free exercise clause has absurd implications. Conceivably, under Sherbert, a devout Quaker could argue that federal taxes are unconstitutional because they pay for war efforts. A Mormon fundamentalist could challenge laws that prohibit polygamy. Or a pair of employees whose religious beliefs require that they smoke peyote, a Schedule I hallucinogenic drug, could make a strong argument for a personal exemption to state and federal drug laws. Under Sherbert, in each of these cases, the government would be forced to prove that its laws served a compelling state interest and that no other feasible ways of addressing that interest existed, which is a very difficult standard to meet. Fortunately, the Supreme Court spotted these deficiencies when it decided Employment Division v. Smith in 1990. Justice Scalia, writing for the majority, essentially abandoned the Sherbert test for a more deferential, common-sense approach to the free exercise clause, an approach that still exists today. The court held that laws that apply generally and do not single out any particular religion do not violate the First Amendment, even if they do happen to infringe on the rights of someone's religious beliefs. Applying this principle, it is fairly clear that a mandate for insurers to cover the cost, of birth control is constitutional. It is a law that applies generally, and it does not single out any particular religion. Those who feel that mandatory insurance coverage of birth control conflicts with their religious beliefs are fully able to engage in the democratic process. They can lobby for more expansive religious exemptions. They can lobby to try and have the mandate repealed altogether. But the United States should never be forced to tiptoe around the religious beliefs of each of its 310 million unique and diverse citizens. An arrangement like this would be inconsistent with the Constitution, and, more significantly, it would be inconsistent with common sense. Thank you.
Every governmental entity which assumes power will at some point abuse that power. And when the Founding Fathers crafted Article 1, Section 8 of our Constitution, they prescribed limits on Congress, the enumerated powers, and they were fearful of an abuse of power. The assumption that lies within Article 1, Section 8 is that anything not enumerated to Congress must be left to the discretion of the states to regulate. In keeping the limited authority of Congress in mind, There are two key reasons why Section 2713 of the Affordable Care Act, the mandate coercing employers to work together with insurance companies to provide universal contraception coverage, is unconstitutional, exceeds congressional authority, and constitutes an abuse of congressional discretion. First, the mandate fails the Lemon Test, thereby violating the Establishment Clause in the First Amendment. And second, the mandate exceeds Congress's authority to act under the Commerce Clause and provides no limiting principle to congressional authority. To my first point, the First Amendment of the Establishment Clause reads that Congress shall pass no law respecting the establishment of a religion. And in 1971, in Lemon versus Kurtzman, the Supreme Court stated that the government bears the burden of proving that each federal statute that burdens private entities must have a legitimate secular purpose, and that the effects of that statute must not result in an intermeddling with religious exercise, and it must not inhibit religious exercise. That's exactly what Section 2317 does. As applied to private institutions such as Yeshiva University, St. John's Law School, the government's mission in providing universal contraceptive coverage directly contradicts the central tenets of those religious institutions. And even worse, under certain circumstances, those institutions will have to pay the cost to further the government's secular objective. That's because as recent as last month, the Federal Register stated that 4 qualifications must be met in order for a religious institution to opt out of providing universal coverage. They must be a nonprofit organization. Their purpose must be to further beliefs which run contrary to providing contraceptives. They must employ people who have those beliefs. And similarly, they must subscribe to those beliefs themselves. But unfortunately, the federal government's definition as to who should be able to opt out, who is exempt, is not sufficient. It burdens those religious employers that don't qualify as religious organizations. And even if you feel comfortable with this type of congressional authority, then let me posit this hypothetical. Let's say that Congress goes to the drawing board and figures out that pork prevents cancer. They provide a huge congressional record, and they say that every dining hall across the United States must offer pork as an effort to prevent cancer among the American people. Once that pork enters the kosher dining hall, permeates its hallowed halls, what happens is that the laws of kashrut are broken, and that could never be repaired. And although universal contraceptive coverage doesn't physically touch the religious exercise aspect of the Establishment Clause, it still has the effect of creating a tension between the government's secular mission and the purpose of such institutions to promote religious ideals. And even if you're not convinced that an as-applied attack can be brought against a statute by these specific institutions, then still, on its face, the statute fails because it exceeds Congress's authority to act under the Commerce Clause. And in 1995, the Supreme Court stated in United States versus Lopez that in order for Congress to regulate an activity, it must have a substantial effect on commerce. And in the past, Congress has used the substantial effects test to try to get private entities in line with the federal scheme. In Wickard versus Filborn, the scheme was to provide a quota at which the small town farmer couldn't just grow an unlimited amount of wheat. And in Gonzalez versus Rake, the Congress sent out a bright line rule saying you can't cultivate marijuana in your backyard. But that's different from what Section 2713 does. This mandate provides an affirmative act, an affirmative duty on actors within the market to cover the cost for commodities. And as Justice Scalia pointed out on day 2 of oral arguments, the federal government should not be allowed to use the insurance market or justifications which lie in the commercial aspect of the insurance market in order to regulate healthcare. And this principle is devoid of any limiting principle. in the sense that if Congress's mandate goes wrong, if insurance premiums go up, what happens is that we have an unraveling of the market. Congress has to interfere again. And what results is we open the door to a Russian doll of promiscuous government interference where they are altering every aspect of every market. There must be some limiting principle to the Commerce Clause. I would also contend that Section 2713 infringes on issues of federalism. When the court in 95 decided United States versus Lopez, they focused on a particular snapshot, a 12th grade student standing in a schoolyard with a gun in their pocket. And they ruled that under the 10th Amendment, to regulate schools is something that's traditionally reserved to the states, and to regulate safety of the citizens is also something that is traditionally left to the states. However, let's look at the snapshot in this case. The young female who makes a mistake at a high school party and the next day has to take the morning after pill, or somebody who takes birth control on a daily basis, or somebody who under the statute seeks education as to reproductive issues. This snapshot deals directly with the health and safety of the American people, and it is something that should be left to the states to regulate. In fact, at least 26 states have regulated in this arena. So I return to my original point. Any government entity which assumes power will at some point abuse that power. And in order to stop the unbridled discretion of Congress and to preserve the fundamental relationship that our government has with the American people, its citizens, and the private entities in this country, the statute must be held to be unconstitutional. Thank you.
Friends, lawyers, countrymen, we are gathered here today to fight the latest pitched battle in America's seemingly never-ending culture war. In this particular skirmish, the issue is the constitutionality of a government mandate for private health insurers to cover the cost of birth control as part of their policies. Before addressing what I believe to be the strongest constitutional objection to such a policy, namely the argument based on the First Amendment right to the free exercise of religion, I would like to proceed first to address some of what I believe to be the weaker constitutional arguments against this law. To begin, there seems to be no solid federalism argument against this mandate. To begin, the question that's certified for our inquiry, if you will, does not specify whether the law in question is applied at the state or the federal level. That is just as well, because at either level, such a mandate would pass constitutional muster. The states, of course, under the Constitution, possess the general police power, which includes the power to regulate their economies. So if we focus on the implementation of such a law at the federal level, where it's almost certain to be far more controversial, we still see that even the federal government has the constitutional authority to require private insurers to cover the cost of birth control. The federal government has the power to regulate commerce between the several states according to the Commerce Clause of Article 1 of the Constitution. To begin, buying and selling health insurance certainly constitutes economic activity. Simply put, offering a health insurance policy on the open market and providing it to all comers, to all customers, in exchange for remuneration is obviously commercial activity. So if there were to be a serious Commerce Clause argument made against this law, it would, in all likelihood, focus more keenly on the interstate aspect of the Commerce Clause power. However, since the 1930s and 1940s, the Supreme Court has expanded its interpretation of the Commerce Clause. Even if the purchase of insurance, in this case, occurs intrastate, which is likely since the various 50 states of the Union have their own licensing laws that make it difficult, if not impossible in many cases, for Americans to purchase insurance across state lines. Even so, even that intrastate commerce is still fair game for federal regulation. That is because, as the Supreme Court made clear in its decision in the case of United States versus Darby and many other cases since then, even intrastate commerce can be regulated by Congress as long as it substantially affects interstate commerce. Now, as extensive research has shown, not ensuring birth control, not providing birth control to women who need it, can cause a lot more costly medical problems further down the line in the long run. So a woman who is not able to access birth control when she needs it, and who possibly becomes unintentionally pregnant and develops some medical complications as a result of that pregnancy, will ultimately end up costing her insurance company more money than she otherwise would have if she had been able to benefit from contraception at the time when she otherwise would have been able to access it if this mandate were in place. Since the insurance companies that dominate the industry in this country tend to have operations in multiple states, and since those more serious medical problems that contraception would otherwise help prevent increase costs for those insurance companies, it stands to reason that failing to provide this insurance coverage for birth control increases the cost of health insurance across the whole country. That is exactly the kind of substantial effect on interstate commerce that the Commerce Clause was intended to give Congress the power to address. Now, many critics have already condemned the mandate on the premise that it violates individual economic liberty, the freedom of citizens to make their own purchasing and consumption decisions without government interference. I can easily imagine many of those same critics attempting to make a constitutional case out of this essentially political objection. As much as I sympathize with their belief in economic freedom, I'm not able to endorse it on a constitutional level. Aside from the threshold fact that the text of the Constitution makes no explicit mention of economic liberty, even if we look at that liberty as one of the unenumerated rights protected by the 14th Amendment right to due process, we see that as a matter of substantive due process specifically, the mandate would remain constitutional. Since New Deal era decisions such as Nebbia versus New York and United States versus Caroline Products, the Supreme Court has applied minimum rationality review to economic regulations of this kind. It almost goes without saying that there is a rational basis for such a mandate. The substantial effect on interstate commerce that I just outlined is just one example of such a rational basis. So let me turn to the strongest argument, a constitutional argument, against the contraception mandate. The idea that when it is applied to religious institutions that provide health insurance, it violates the First Amendment right to the free exercise of religion. Even this challenge also fails, for the mandate does not single out religious belief for persecution or discrimination. Now, in the 1990 case of Employment Division versus Smith, the Supreme Court upheld the state of Oregon's denial of unemployment benefits to the respondent. In that case, the respondent had been convicted of violating a state law that prohibited the use of peyote, even though he had a religious basis for using the drug. Now, drawing on precedents dating back to the case of Reynolds versus the United States way back in 1879, the Supreme Court made clear that even a law that burdens religious exercise is nonetheless presumptively constitutional as long as it is a neutral law of general applicability. Otherwise put, as long as the law does not specifically target religious practices for discrimination, it passes constitutional muster. A contraception mandate undoubtedly passes this test with flying colors. As long as the mandate applies to all insurers across the board, whether they are religious or secular institutions, the mandate satisfies this non-persecution principle. Now, it is widely contended that this is an unduly narrow interpretation of the Free Exercise Clause. After all, even neutral, generally applicable laws still often substantially burden religious exercise. For example, surely a law that requires the Catholic institutions to ensure a form of conduct that violates one of their core tenets burdens the exercise of Roman Catholicism. Why then should the Constitution not lift such a government yoke off the backs of the faithful? It does not and should not, because such a policy would unfairly privilege religious believers over the rest of society. Suppose, for example, that two employers equally objected to such a contraception mandate on principled grounds, one of them for religious reasons and the other based on secular philosophical premises. Under the free exercise standard espoused by the constitutional challengers of this mandate, only the religious institution would be able to benefit from a judicially crafted exemption to the law. Meanwhile, the secular institution would be out of luck, even if both parties are equally fervent in their opposition. It is not difficult to see the unfairness of such a principle that would give religious believers a privilege unavailable to their secular, equally well-meaning fellow citizens. Moreover, there is a danger that such an expansive construction of the free exercise clause would endanger the rule of law. Scofflaws could dishonestly claim to have religious premises for their illegal acts in order to cheat the justice system. Individuals could literally fabricate whole new faith traditions out of thin air in order to escape the constraints of the law. Judges would either have to hold their noses and cater to this chicanery, or they would have to resort to directly interpreting professed religious beliefs and practices in order to evaluate their authenticity or their centrality. This would be a perilous course of action for judges to take, and one from which judges uniformly and rightly recoil. Judges are poorly equipped and trained to distinguish real religions from false ones. Moreover, trying to do so would arguably violate the Establishment Clause of the First Amendment by excessively entangling the state with the church. So in all, a contraceptive mandate that applies to all insurers would not violate the Constitution. This is not to say that this policy would necessarily be the fairest or wisest policy. It is merely to say that the right place to fight this fight against the mandate is not in unelected courts of law, but in the political process. That is exactly where such battles rightfully belong in a society that is based on government of the people, by the people, and for the people. Thank you very much.
Many proponents of the mandate requiring birth control coverage will often begin their tale with a story. When Sandra Fluck testified before the United States Congress, she told a story about her friend who, because she could not afford birth control, lost an ovary and will now have trouble conceiving her own child. When my mother was 38 years old, she suffered from what her doctor considered a health condition, a completely preventable health condition, a condition that could have killed her, a condition that the medical community abhorred, because when my mother was 38 years old, she chose to conceive, and she had me. Now, of course, having a family and having a child, that's not strictly a medical condition, but medicine is, of course, involved. In the United States of America, and in Harrison's Principle of Internal Medicine, Dr. Harrison explained that in our country, where we have some of the most outstanding medical advances the world can offer, 1 in 7,500 live births will result in the death of the mother. 1 in 7,500 women will perish, not because they were in the deserts of sub-Saharan Africa, where the death rate is 1 in 200, and not because the doctor committed an error, but because they gave birth and the complications that result. Conditions like placenta previa, where a woman's cervix is completely covered or partially covered by the placenta, and when a woman tries to give birth, she simply bleeds to death. Or another condition, such as gestational diabetes, where a woman's blood sugar can either crash or spike to such a degree that they fall into a coma. These are medical issues that can be prevented with a medicine. a medicine we refer to as contraception. Opponents to the mandate will, of course, rely upon what they consider a shield to their rights. They will look to the First Amendment free exercise clause and claim that this law abhors their rights. But they're wrong. And we know they're wrong. And the Supreme Court has said so. In Employment Division versus Smith, the United States Supreme Court explained that a neutral, generally applicable law does not violate the free exercise clause. And to make such exceptions as to empower certain groups or certain individuals to circumvent the law would permit every citizen to become a law unto themselves. All this law would require, all that we are asking, is that an employer provide the medically necessary medicine to a patient, and that they not empower themselves become doctors. Now, some opponents would claim that, well, this is preventative medicine, so would closing your legs. Just don't have sex. Just choose not to be in the arms of your husband. Just don't do it. But that's not what we do in America. In America, we respect the freedom of our citizens. In America, our medical community and the American Medical Association, as well as the American Congress of Obstetricians and Gynecologists, have all discussed treating the patient and treating the symptoms. For the same reasons, we don't shout at somebody with high blood pressure to put down the salt. We give them beta blockers. We don't shout at someone who has high cholesterol, put down the red meat. We give them Lipitor. We don't tell a diabetic just to put down the donut. We give them insulin. For those very reasons, when a woman chooses and when her doctor advises that she take a medicine to ensure the safety of her body, of her health, that is a medical decision that should be funded by those employers. Some opponents have used the parable of the kosher deli. They have explained that this mandate is akin to forcing a kosher deli owner to sell pork. As a Jew, as someone who's familiar with kashrut law, and as somebody who just likes a good kosher deli, I find that analogy to be abhorrent. What it really is, what overturning this mandate would be empowering the kosher deli owner to deny his employee a porcine heart valve. A heart valve where, when an individual suffers from congenital heart disease, would save their lives. The type of porcine heart valve that would be prescribed by a doctor, like birth control. Prohibiting this mandate would be empowering that kosher deli owner to say no heart valve, just because it's not kosher. I got married less than a year ago, and I look forward to the family I'm going to have with my husband. I look forward to the day that I can discuss having a family with him and discuss my medical options with my doctor. And in absolutely no way, shape, or form should my employer have any say to what I'm doing with my body or what my doctor prescribes for me. This law does not violate the Constitution. Saying so violates human decency. Thank you.
Good evening. The question before us is actually comprised of two subordinate questions. First, does Congress actually have the power to regulate the content of health insurance policies? And if it does, what would that legislation have to look like in order to pass judicial review? Let's get right to the heart of the issue. Does Congress have the power to regulate insurance policies? The answer to that question is an emphatic yes. In fact, the Supreme Court already decided this exact issue in the 1944 case of U.S. versus Southeastern Underwriters Association. And in that case, the Supreme Court held that Congress, under the Commerce Clause, has the power to regulate policies of any kind of insurance. Pursuant to the aggregation principles of Wickard v. Filburn, the Supreme Court found that insurance policies had a $37 trillion impact on interstate commerce. That's more than the value of every tract of farmland and every single building in the entire United States combined. And because of that fact, the Supreme Court held that the Commerce Clause gave Congress the power to regulate even locally negotiated and locally executed insurance policy contracts. Those intangible contracts could be regulated just like any tangible product. And thus, minimum standards could be required upon those contracts, just like minimum wages had already been required upon employment contracts in U.S. v. Darby. In fact, our entire modern idea that insurance is more of a state than a federal issue actually comes from Congress using its Commerce Clause power and passing an act pursuant to the Southeastern Underwriters case. The year after Southeastern Underwriters was decided, Congress passed the 1945 McCarran-Ferguson Act as a direct result. And that act statutorily allowed states to take the lead in regulating insurance, unless and until Congress decided to preempt those state regulations. In other words, states would serve as laboratories of experimentation until Congress decided the experiment was over. But does birth control itself actually have enough of an impact on interstate commerce to give Congress a rational basis with which to require it to be included in health insurance policies? Absolutely. The CDC and dozens of other independent studies routinely show that unplanned pregnancies have at least an $11 billion direct effect upon interstate commerce. And the Supreme Court has already found that $11 billion is a sufficient impact to be regulated under the Commerce Clause, because $11 billion is the exact same dollar-for-dollar impact on interstate commerce that the black market for marijuana had in Gonzales v. Raich. And while Congress doesn't have to prove that covering birth control will actually be effective at reducing the $11 billion cost upon interstate commerce, data from the 28 states that already require this coverage make clear that there is an average of 200 to 600% savings for every dollar used to procure birth control. In fact, the House Ways and Means Committee recently estimated that just a 30% reduction in unplanned pregnancies will pull 25% of America's poorest children above the poverty line. And because nearly half of all unplanned pregnancies result in abortion, that same reduction could prevent nearly 450,000 abortions every single year. So now that we know that Congress has the power, the question becomes, how can Congress draft its legislation to ensure that it stays well within its Commerce Clause power? It can do four main things. First, as the current Supreme Court debate shows, don't force anyone to buy birth control or require anyone to use birth control. Congress can simply do here what it traditionally has done: require products to meet certain minimum standards before they can be introduced into the market. Second, they can limit the requirement to doctor-prescribed birth controls and have it only apply to insurance plans that already cover prescription medication and prescription medical devices. In other words, don't force vision or dental or emergency room only type coverage to start covering things that they don't already cover. Third, explicitly include a jurisdictional hook and expressly state that Congress is using its Commerce Clause power to regulate insurance. This safeguards the legislation against cases like U.S. v. Lopez and keeps Congress from having to amend the McCarran-Ferguson Act or any other state or federal current insurance framework. And fourth, make the law part of a larger regulatory scheme. This will avoid the pitfall of single-issue legislation raised in U.S. v. Morrison. For example, birth control could simply be part of a larger preventative care framework and could include required coverage for things like vaccinations or prenatal care, both of which independently have their own significant effect on interstate commerce. And finally, it must be noted that just because a law is facially constitutional doesn't mean it can't be attacked on an as-applied basis. That means that religious institutions can still challenge the constitution of the law as applied to them, something that many states' birth control coverages right now don't allow. So thus, if Congress carefully drafts its legislation, it can constitutionally require insurance companies to cover birth control and still stay well within its Commerce Clause boundary precedents. Thank you.
Benjamin Franklin is often attributed with the quote, "Those who would sacrifice essential liberty for the sake of personal safety deserve neither." And this was a man who certainly knew what he was talking about. He ate lots of red meat and invented the swim fin. But when our current president, who has yet to invent anything, signed into law the Patient Protection and Affordable Care Act, he unleashed a liberty-squashing mechanism of unfathomable proportions, supposedly for the sake of safety, by depriving individuals of the ability to choose how they will pay for their health care services. Now, the constitutionality of that provision of the law will be decided by the Supreme Court in the next few months. But the provision at issue tonight, requiring insurance companies to cover birth control costs for their subscribers, is an entirely separate matter that's created a political firestorm in the past few weeks. Ultimately, this law is unconstitutional because it violates both the Commerce Clause, and Congress does not have the authority to enact this law under its taxing and spending power. Now, previous speakers have already discussed the Commerce Clause issue, but the government's response to those arguments is best encapsulated in how it defended the individual mandate in the recently argued Department of Health and Human Services versus Florida. The government's argument, even if ineptly argued by Solicitor General Verrilli, is that the healthcare market is one in which the entire country participates, and the decision of how to pay for those services shifts costs among consumers across interstate lines. Thus, it is an economic decision that transcends state boundaries and is subject to congressional reach. And even if that is not persuasive, it's at least cogent with response to the individual mandate. But the government's attempt to cross-apply that argument to the birth control mandate simply does not pass constitutional muster. The birth control market is not one that's universal. At best, it only applies to the part of the American population that is women. And even then, it only applies to the subsection of that population that chooses to use birth control services. Moreover, all of the cases that the government cites in order to defend the provision still reflect the fact that it has to be an economic decision. This is what was at issue in Wickard versus Filburn, where Farmer Filburn was trying to sell his wheat on the market, or rather was trying to keep his wheat that he did not sell on the market. In United States versus Lopez, the Supreme Court said that having a gun in a school zone is not an economic decision, so laws regulating it are unconstitutional. In United States versus Morrison, laws regulating violence against women are unconstitutional because spousal battery is not an economic decision. Gonzalez versus Wright said that growing marijuana at home is an economic decision, so laws regulating it are constitutional. But as every single one of the previous speakers has pointed out, there are so many other reasons why a woman would choose to purchase birth control, such as for health reasons, or reasons why one might not purchase birth control, such as religious ones. These are individual, non-economic decisions, and that's the crucial point. Even if birth control may have a substantial effect on interstate commerce, it's still a local, non-economic choice that a woman makes that cannot be touched by Congress. But even setting that aside, Congress might attempt to pass the mandate doing what it usually does when it doesn't have Commerce Clause power: get the states to do their dirty work. The argument would be that the Congress could incentivize the states in order to enact its policy regime, requiring insurance companies within their boundaries to cover the cost of birth control. And as has already been identified, 26 states already require their insurance companies to cover the cost of birth control. The problem comes with the other 24 states. Article 1, Section 10 of the Constitution says that no state may pass any law impairing the obligation of contracts. As the Supreme Court described in the 1938 case of Energy Reserves Group versus Kansas City Light and Power Company, when a state intervenes in an already existing contract and imposes new obligations or requirements, it is acting unconstitutionally. That applies here for the millions of American women who have a health care plan that does not cover birth control, but choose to keep it anyway because it's financially sound for them and because it meets the Affordable Care Act's requirements for health insurance. If that state were to intervene in those contracts and require the coverage of birth control, it is again acting unconstitutionally. But even if you don't buy that argument, you still run into due process problems because of the interstate exchange for insurance that the Affordable Care Act establishes. what you would ultimately end up with is citizens choosing plans from their own state or from another state in order to get birth control coverage while the same state is treating their own citizens differently. This is a fundamental due process problem, and that, along with the Contracts Clause, prevent Congress from exercising its taxing and spending power in order to affect this regime. So ultimately, this is an intriguing and important debate that this country has to have about whether the federal government can require insurance companies to cover the cost of birth control. But ultimately, it has neither the power under the Commerce Clause or its taxing and spending power to do so. To be clear, I agree with the other speakers that birth control is an important tool for women to have when discussing their health options. And I fully support the government's efforts to make that tool available to as many women as possible for as cheap as possible. Politically, this is a problem that can likely solve itself through the interstate exchange that the Affordable Care Act establishes. When states or when individuals choose plans from other states that cover the cost of birth control, those plans will become more popular. They'll be in higher demand, and more insurance companies will have an incentive to cover the cost of birth control. But this mandate is not the right way to go about achieving that goal. It's an individual's decision about whether they will choose a plan that covers the cost of birth control. Congress must respect the individuality of that decision. Stand back and leave these people alone.